Welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Jorge Contreras, Professor of Law at the University of Utah S.J. Quinney's College of Law. We will discuss his article, Sui-Genericide. So welcome to the program, Jorge.
Thanks very much for having me.
So I got to tell you, this title is one of my favorite I've seen in quite some time, and I can't wait to talk a little bit about the title and sort of what it means and why it's such a sort of funny and appropriate title for the piece. But before we do that, I was wondering if we could spend some time just kind of situating listeners in trademark law and the concept of genericness in trademark law. So what is a generic mark, and how do generic marks relate to other kinds of marks in trademark law?
Right. It's a good question. So the fundamental basis of trademark law is that we give legal protection to words and other devices that indicate to consumers what the source of a good or a product is, right? So that you see the red aluminum can with the Coca-Cola word on it, you have some idea about what the quality, whether you think it's a good quality or bad quality, is of the drink inside of that can. It indicates to you the source of that beverage. There is a whole spectrum of strength of trademarks, and things like Coca-Cola are quite strong, they're quite distinctive, but you can have much less distinctive marks as well, marks that are either just suggestive or descriptive, or at the bottom end of that spectrum, you have words that cannot be used as trademarks at all. And those are what we call generic terms. They're not, generic marks, they're just generic terms, generic words. And those are words that just describe a general category of things like chair, or table, or car. If I want to become a car manufacturer, I can't really call my new car brand car, right? That's a generic term that describes this entire category of products. I have to come up with some other name like Lexus or Mercedes-Benz or Prius to distinguish my car from other types of cars and to indicate the source of the car.
Right. So a generic mark, or a generic term, is really just a word that refers to a category of products, or like it's just the noun maybe that we use to name whatever it is that we're talking about, as opposed to something that'll tell us what particular product we're looking at or where it's coming from.
Exactly. The generic term is a category of products, and you can have many different specific brands or producers of products within that category. And we don't allow any one manufacturer to get trademark protection for the generic term.
So there's a concept in trademark law called genericide. So I wonder if you could talk a little bit about what that is and what it means.
Right. Sure. So in the abstract, when we talk about marks being generic or not, there are certain legal standards and tests that we talk about. But in order for a mark to become generic, somebody actually has to do something. This doesn't just happen sort of naturally of its own accord. And for a mark to become generic, or for a term to be declared generic, there are two sort of legal processes where that can happen. One is at the Patent and Trademark Office, when the trademark examiner reviewing an application says, you want to call your new car, you can't do that. That's generic. So in the examination stage, a term can be called generic and a mark application can be rejected. Second, after a mark is already granted by the Patent and Trademark Office, it can be challenged as generic later on. And this can happen in a few different venues. There are procedures within the Patent and Trademark Office to challenge or oppose these marks, and this can also happen in litigation. But these procedures are all pretty similar, and basically somebody challenges the mark and says, okay, well, you got a trademark on that particular word, but for better or for worse, it is now considered a generic term. And we've seen this happen from time to time as marks that have been registered have become so common in their usage that they become generic. And that's what we call genericide. It's sort of a pun derived from the word homicide, to kill, right? And when you challenge a mark as being generic and succeed, and the mark is basically killed and is no longer enforceable. And that's what we call genericide.
So how do we know whether or not a mark is generic? And is that a different question or the same question when it's asked by the examiner or when it comes up in a litigation or some other form of kind of challenge to the mark itself? In other words, is that like something that is done to the mark, or is it like a description?
So genericide is not an official legal term. That's just a term of art that's used in the field. All of these challenges have their own particular procedural requirements and burdens of proof and so forth, but they all generally ask the same question, which is whether this term describes a general category of goods and services or whether it indicates the source of those goods or services. The examiner asks that question, and the court will ask that question when a mark is challenged in court. There are procedural differences, but probably not worth going into. That's the basic question.
So maybe you could give a couple examples of marks that at one point were good trademarks that indicated source, but later became generic marks, and sort of just give listeners a sense of sort of how and why that might happen.
Sure. There's a whole range of these former trademarks that have become generic. Things like escalator and cellophane, right? These today are common household words. We use them to describe like a moving metallic staircase or a plastic wrap for food. At one time, there was a general escalator company, and it viewed escalators as a proprietary name, an indication of source. Today, of course, we don't. And there are dozens of these, and they're actually very fun lists of them out there in the literature. Aspirin is one. There are quite a few.
I mean, it seems like the process is almost like a double-edged sword in a sense, because on one level, a producer of a good would want the name of their good to be so ubiquitous that consumers would use it as a synonym for the good itself. But on another level, if it gets too ubiquitous, then it sounds like they might run into trouble. Is that a fair assessment?
Absolutely. Absolutely. Mark owners have to be very careful. And this is precisely the trap that many of these older mark owners have fallen into. They like for everybody to call the moving staircase an escalator, because then when a department store wants to install one of these moving staircases, who are they going to call? Well, of course, they're going to call the escalator company. So that's great for marketing. But then without an alternative generic term that you can use to refer to the thing, to refer to your competitors' products, you're going to lose your mark.
Right. So what do companies try to do then in order to, encourage consumers to have awareness of the mark that they're using, but not to conceptualize it as a synonym for the good or service itself?
Yeah, so smart mark owners have developed a whole series of tactics that they use. And probably the best known of these in the trademark literature is a Xerox Corporation. We don't really make that many photocopies these days, but Xerox was, of course, a pioneer in the photocopying industry. And there was a time when when you talked about wanting to photocopy something, there's a good chance you were going to say you were going to Xerox it, and the pieces of paper that came out of it, you would call them not photocopies, but Xeroxes. And the Xerox Corporation spent lots and lots of money, millions of dollars, on advertising campaigns and public awareness campaigns to convince people to call that act photocopying and to call the papers that came out of the machine photocopies, and to then distinguish its photocopiers as Xerox photocopiers. That worked. But to do it, Xerox for decades ran advertisements in newspapers and on radio, trying to convince people that their thing was called a Xerox photocopier and not a Xerox. And things, other companies have tried this as well. So Scotch tape, Kleenex, Vaseline, all of these companies went through some efforts to create generic terms to describe really a product category that they invented with a generic term so that they wouldn't lose their proprietary mark, right? So we have Kleenex facial tissue and Vaseline petroleum jelly. These types of tactics are relatively effective. The best one, the most recent one, has been an effort by the Velcro companies. Velcro, as we all know, is that sort of fastener contraption that you use on shoes and wall hangers and whatnot. It keeps things stuck together, and it's made out of thousands of these little tiny plastic hooks and loops that latch together. And there's a famous David Letterman episode where he puts on a so-called Velcro suit and gets thrown up against a wall and sticks there to show how effective the product is. But the Velcro companies got the idea that people are going to start to call this type of fastener, which is old. It was invented 60 years ago, right? So the patents are all expired. And copycats can come onto the market. And if you're the Velcro companies, you don't want everybody calling those imitation products Velcro, because that should indicate your company and your source. And so the Velcro companies have put together this very clever set of videos, music videos, which are available on YouTube, that urge you, not to use Velcro as a generic term, to call the product hook and loop fastener, and to call it a Velcro hook and loop fastener. One of the lyrics is, if you keep calling these Velcro shoes, our trademark will get killed. It's actually worth listening to.
So normally companies are really doing their utmost to prevent the mark that they're using from becoming a generic term for the product category. But in your paper, Sui-Genericide, you talk about this opposite or alternative phenomenon where companies or groups of companies might want to make a mark to kind of stipulate that a particular term is a generic term rather than a source indicating term. So I wonder if you could talk for a minute about why that's a particularly kind of difficult or potentially difficult thing to accomplish in the trademark sphere, as opposed to how we would think about doing kind of an analogous thing in the copyright or patent sphere.
Sure. It's a really interesting distinction among these different types of intellectual property. So patents and copyrights have mechanisms, legal mechanisms that are available so that if the owner of a song or a copyrighted poem or a novel wants to put it out into the public domain, they can do that. With patents, if you invent something, there are numerous ways either to abandon it to the public by publishing it so that other people can't patent it, or if you already have a patent or patent application, there are procedural ways to abandon it. And once you do that, I invent a new type of mousetrap, and I patent it, but then a year later I decide, well, I'd rather just contribute this to the world for the good of mankind. I can abandon my patent, and then nobody else can get a patent on that mousetrap invention, right? I mean, it's known to the world. I was entitled to patent it because I invented it, but after I've abandoned that, nobody else can do that. This is not the way that trademark registration works, and we see this happening all the time. A trademark application can be abandoned because, who knows, a company goes out of business, or it decides it doesn't want to pay registration fees, or it has a mark for a while and then it stops using it. For all of those reasons, you can lose trademark protection on a mark. But once you lose your trademark, then it's up for grabs again. Anybody else can claim it and register it as their own trademark. And so there's no real way under the trademark law to abandon a term to the public. And with genericism, there's no way for a company who wants their own term to become generic to declare that it's generic, right? I mean, as we discussed earlier, the ways that marks are declared generic are either, in the application stage by the examiner, or in a litigation or an opposition proceeding later initiated by a third party. There's not just a way to slap a label onto a term and say, hey, I came up with this term, but you know what? I now want the word Prius to be a generic term for electric cars. That is just not available.
So, George, in your paper, Sui-Genericide, you talk about this really interesting phenomenon in relation to the concept of genericide, in the sense that it's sort of like the analog of what happens in a circumstance where there's a risk or the possibility that consumers will start using a term in a generic sense. And it seems like it sort of reflects something sort of really fundamental about trademark law, which is like that, when it comes to a mark becoming generic, companies can encourage consumers to use the mark in a brand way. But if consumers don't do what they're told, then there isn't really anything the companies can do about it. And in a weird way, it seems like exactly the same thing happens in the other direction. It's like the companies can encourage consumers to use particular terms as generic terms, but they can't force consumers to use the terms in that way. Is that the right way to think about what's going on here?
Yeah, absolutely. I mean, at the end of the day, a company saying this term is or is not generic in our legal system doesn't really carry much weight. What courts and examiners and others will want to do is look at things like evidence, consumer surveys, and so forth to see how consumers are actually behaving. And you're right, companies can try to convince consumers to say one thing or another, but they can't force them to.
So why is this a problem then for companies? I mean, I can understand why a company would want to preserve the trademark quality of a brand name, even if it started to become sort of used by consumers as a generic or a potentially generic term. But why would companies want to make a term generic, right? Why would they want to place something in the sort of trademark public domain, and what might frustrate that move?
So the reasons you would want to do this go back to sort of the middle of the 20th century, right? When companies who were competing with each other realized that it would benefit all of them if there were some generic word that could describe their product, that they could then differentiate using their own brand name, something like elastic, right? That's a term that we consider today a generic term, but back in the 40s when elastic, I guess, was first invented, that wasn't necessarily known. So a number, 10 different clothing manufacturers all think it would be good if they could, use the term elastic to describe their swimsuits, waistbands. But the Hanes company, and the Polo company, whoever makes these products, none of them are going to register that as a trademark, but somebody else could, right? So what happens if the Hanes company and other clothing manufacturers all start to call their thing, elastic waist swim trunks, and then somebody comes along and tries to register that as a trademark? That could be a problem for all of them. And so there was this thought that it would be good if industry members could get together and decide on some generic terms that nobody would trademark, right? Decide up front that the word elastic would be generic, that none of them could trademark it. They could all use it to describe their own products. Right? And so that principle today, I think we can understand it most clearly in terms of drug names. Drugs have three different names. Every drug does, right? It's got a brand name, it's got a generic or a common name, and it's got a chemical name. So in theory, the chemical name is generic. It's usually a really long, complicated thing that consumers can't pronounce and nobody's going to remember. On the other hand, it's useful to have a term that describes a drug generally based on its chemical class and what it does. And this is important for consumer safety, right? For prescribing and so forth. So let's take the example of ibuprofen, right? Ibuprofen is a common name, a generic name for a category of pain medication. Like the chemical name for ibuprofen is RS-242 methylpropylphenylpropanoic acid. Doesn't exactly, flow off the tip of your tongue. So with that chemical compound, drug manufacturers got together and decided, okay, that long, complicated RS-242 chemical name, we're going to call it something that we're all going to call it, and none of us are going to get a trademark on that name, and that name is ibuprofen. And then on top of ibuprofen, manufacturers will get trademarks on brand names like Advil and Motrin, right? Advil and Motrin are both brand names of drugs, and they are both ibuprofen. They're pretty much the same thing, or they have the same active ingredient, but they differentiate themselves based on brand. And so the manufacturers of Advil and Motrin and all the other ibuprofen products did get together and come up with the name ibuprofen as generic. And none of them want somebody to register the name ibuprofen anywhere, because that would then, claim as a trademark some term that they're all using. And yes, they could potentially challenge it, but wouldn't it be better if we could all just agree up front that it's going to be generic from the start?
So one of the things I thought was really interesting, and I was unaware of before I read your paper, was that at least for a period of time, there was sort of like a sort of programmatic institutional effort, it seems like, almost, to preserve the genericness of certain terms. I wonder if you could talk a little bit about that and sort of maybe speculate about why that stopped.
Yeah, so starting in the 1940s, the U.S. government tried to be very proactive in helping U.S. industry in a variety of ways. And the way this first started was because U.S. manufacturers of drugs and other products were starting to notice that in other countries, say in Europe or in Latin America, companies were beginning to seek trademarks on words that in English seemed generic, right? Things like vitamin and folic acid, right? We might consider these generic terms in the US in English, but, take in Germany, the word vitamin does not exist as a word in the German language. And so it kind of sounds like a novel term that should be able to be trademarked. But if a German company gets a registered trademark in Germany on the word vitamin, well, then what happens to all of the U.S. companies that are exporting vitamins to Germany? They can't call them vitamins anymore. And so believe it or not, the Department of State actually, or the Department of State and the Department of Commerce got together and realized that this could be a problem for U.S. companies, and they created this really interesting program in the late 40s called the Generic Word Program, where the government would hear complaints from U.S. companies about different words that were being trademarked abroad. And then we would, through diplomatic channels, tell these foreign governments, hey, the word vitamin, we see that some German company has tried to register it, but you shouldn't register it because it's actually a common English word. And that diplomatic process had mixed success. Eventually, funding ran out for these government programs, but they were taken up to a degree by private sector programs. And so, especially in the pharmaceutical industry and some others, trade associations, including the International Proprietary Association, the American Medical Association, all got together to try to systematize and stop sort of spurious registrations of these terms that everybody thought should be generic. And that led to an interesting international system of designating terms in particular industries as generic. We have it in the drug industry, we have it in the pesticide industry, in the synthetic fiber industry, right? As we moved from everything, clothing all being made out of cotton or wool, to things like rayon and polyester, clothing manufacturers are required by law in the U.S. to label their products as, 50% polyester, 50% rayon. Those words, polyester and rayon, were created, believe it or not, by the Federal Trade Commission, who was initially put in charge of coming up with these lists of generic synthetic fiber names so that people could accurately label their products. Again, as we got into the 80s and the idea of shrinking government began to take hold, government agencies, the Department of State, the Department of Commerce, the Federal Trade Commission, got the idea that, we really shouldn't be in the business of coming up with lists of synthetic fibers and pesticides, right? That's best left to industry associations. And so this task was sort of fobbed off to groups like the American National Standards Institute and ISO, the International Standards Organization, and they came up with these names through industry task forces, and eventually, in some cases, they're recognized by the government agencies that used to be in charge of them.
I mean, it seems like, at least when it comes to sort of this idea about foreign words, there's at least a kind of echo of that overseas program in U.S. trademark law as well. And so far as there's, as I understand, like kind of a bar, or a statutory bar almost on using generic foreign words as trademarks, or registering them as trademarks in the United States, at least in certain circumstances. Do you know if those kind of had a similar source, or did they come from different places?
Yeah, so that doctrine, the foreign words doctrine, is kind of a mixed up one. And there are cases that, so you're right. And the rule in the United States is you can't register as a mark something that is a generic term in a foreign language. And so you get cases around things like the La Posada Hotel. La Posada, is that something, is that that's a Spanish word? It kind of means an inn, but is it a common word? I mean, in Latin America, you don't really talk about, that anymore. It's kind of an archaic term. So it's controversial. It's even more controversial and fragmented in other countries. And I would recommend Bob Brownice at GW has an excellent paper that he and a European co-author just published about this idea of, foreign words and how they can be registered in countries where that's not the native language. The paper is about a Spanish registration of the word matrasen, which is the German word for mattress, but is not the Spanish word for mattress. And so it's similar. It's a similar set of issues, but also somewhat different because with the Sui-Genericide movement, you have companies affirmatively trying to get out ahead of these trademark registrations, not challenging registrations that there are, but sort of precluding others from making these registrations in the first place.
Yeah, I mean, and from the paper, I mean, it sounds like this is especially important and, kind of especially an issue when it comes to standard setting and sort of creating industry standards. I mean, to what extent do you think the trademark office is, sort of conscious and sensitive to the need for this kind of standard setting? And is it consistent with the way that the trademark office and the courts are kind of conceptualizing what it means for terms to be generic terms as opposed to potentially source indicating trademarks?
Yeah, the issue of technical standards is sort of the new incarnation of the Sui-Genericide movement, right? You had these programs that started in the 40s and 50s and, kind of linger today. But what I think the really interesting thing is coming up in this standardization area. So, we have standards that affect all of our electronic products from Wi-Fi and LTE, 4G, and whatnot. They're common household words today, right? The term Wi-Fi, everybody knows what it is, but it is also a trademark and a certification mark of a particular organization. And so they would argue very strongly that Wi-Fi is not a generic term that describes, your wireless home network, but it is a particular standard, a family of standards developed by this standards group called the Institute of Electrical and Electronics Engineers Standards Association. Their number is 802.11, A, B, G, N, A, B, what you will. So is Wi-Fi generic? There's a little bit of a debate about that. But some standards bodies have actually tried to declare that the names of their standards are generic, which is potentially an odd move, right? The Wi-Fi Alliance, which owns the term Wi-Fi as a certification mark, spends lots of money registering that mark around the world and enforcing it. But you've got a couple of standards bodies. So, for example, the USB Interoperability Forum, USB Implementers Forum, USB-IF, right? That is the group that sort of maintains the USB standard. USB, of course, is this ubiquitous standard that we use for memory sticks and plugging peripherals into computers and all sorts of things. We use it for charging these days. That was a standard developed by a group of companies, and there are a bunch of terms associated with USB. But the USB Forum itself declared in a trademark trial and appeal board proceeding that their mark, that USB itself, was a generic term. Why did they do this? Well, because somebody was trying to register another mark that contained the term USB in it, USB house. The USB Forum intervened and opposed that mark, and their principal argument is that, look, this term that we invented, that we created for this standard, is actually a generic term. So no one should be able to register a trademark using it without disclaiming the term USB in their mark. The World Wide Web Consortium has gone a step farther, right? World Wide Web Consortium is responsible for lots of the standards that relate to the World Wide Web, which is the public face of the internet for most people. And so standards like HTML and XTML and HTTP, these are standards that W3C is responsible for in some way. And on their website, they list 20 different terms, including HTML, HTTP, XML, and a bunch that you've probably never heard of as generic terms. A really interesting approach, right? I mean, especially HTTP is not even advanced through W3C. There's another standards body that has primary responsibility for it. But they're out there saying, use it. Use HTML. Anybody should be able to use HTML. It just describes generically this protocol for hyperlinks that everybody should be able to use.
So, George, in closing, I wonder if you could reflect a little bit on what your observations in this paper tell us about the nature of genericness in trademark law. Because it couldn't help but strike me that, we normally conceptualize it as sort of descriptive, this mark has become generic because it's used in a generic way. But it almost seems like the phenomena you're describing sort of underscore the extent to which there's a policy element to the concept of genericness as well. In other words, we sort of identify potentially terms and say, this is a generic term and because it should be a generic term.
Right. And we generally give very little respect or legal recognition to sort of statements that companies make unilaterally about genericism, right? Otherwise, Coca-Cola could just go and say, you know what? I think the term Pepsi is a generic term and we should all treat that as generic. It's obvious that kind of thing shouldn't happen. And so for that reason, we have generally insisted on having some kind of evidence before us, before a court, before an examiner, before something is deemed to be generic. But, that actually costs money. You have to have a motivated challenger to do that, and they have to spend some money. And not only that, they might not win. If you're challenging Coca-Cola's mark, no matter how smart you might be, the company has a lot of money and just might legally outgun you or outmaneuver you. And so when we're talking about sort of the public domain of names and words that we use in the language, it might be preferable to have an easier way for things to be classified as generic other than an adversarial proceeding that is, depends on finding somebody who's financially motivated to bring it and having the resources to mount that challenge and then to be successful. And sort of the conclusion of the paper is, well, we don't have such a mechanism yet, but there are some modest potential changes that could be made to the law by which these declarations of genericide could potentially be recognized. Maybe they could be recognized if they are not unilateral declarations by one company, like the Coca-Cola company, but by some representative group of companies, like the pharmaceutical industry or the synthetic textile industry, where everybody gets together and decides that, okay, ibuprofen, that should just be generic from the outset. We don't want to have to fight some guy who's registered ibuprofen in 20 different countries from the beginning. Let's just have maybe a legal presumption that if this group gets together and by some consensus decision-making process, they agree that ibuprofen should be generic, well, maybe we should create a legal presumption that it is generic, and trademark examiners should potentially recognize that presumption, which today they don't.
Cool. Yeah, no, that makes a lot of sense. Well, thank you so much for coming on the show today, George. It's been a real pleasure talking to you about this excellent paper, and I hope readers will dig into it a little deeper because we've only really scratched the surface.
Yeah, absolutely. It was a fun paper to write, and I really enjoyed speaking with you about it.
We're a company that's so successful that everywhere you go, you see the scratchy, hairy fastener, and you say,
"Hey, that's Velcro!" But even though we invented this stuff, our patent lapsed 40 years ago. Now no matter who else makes it,
You still wanna call it Velcro.
you think it's awesome for us, we're famous, but we're lawyers and it's causing us grief. Cause there are trademark laws being broken. It's all here in this short legal brief.
And we know that this is confusing because Velcro brand is who we are.
But if you call it all Velcro,
We're gonna lose our circle.
This is called hook and loop. This part's a hook, this part's a loop. You call it Velcro, but we're begging you. This is f***ing hook and loop.
we know this seems ridiculous. This is a first world situation.
And we made $500 million last year.
I went to Turks on my last vacation.
And we're asking you not to say her name. We took 60 plus years to build. But if you keep calling these Velcro shoes, our trademark will get killed. Yeah!
We aren't just doing this for us. We're doing it for all the successful brands that got so popular, people started using the brand names the wrong way. So please, remember.
If you need something to clean up your socks, do it with bleach and not with If you have blood from a boo-boo you made, this is a bandage and not a If you're exercising with someone you're dating, it's inline skating and not I know that bleach stuff is more fun to say, but if you keep doing it, our trademarks go away.